Hey everyone, and welcome back to the Texas Business Court Insider. I'm Rafe Schaefer, and I'm here with my colleague, Kate Ergenbright.
Today we're going to be covering a matter of first impression from the Texas Business Court, specifically from the First Division of the Business Court, which is whether the court has jurisdiction over a 202 petition.
The case is in re Radical Hoops Ltd. And Radical Mavericks 2 LLC. Before we dive in, Kate, will you just remind us what a 202 petition is?
Sure. A 202 petition refers to Rule 202 of the Texas Rules of Civil Procedure. That rule allows a litigant to petition a court for an order authorizing a deposition, whether an oral deposition or a deposition on written questions, before a lawsuit is actually filed. So the rule limits this pre-suit discovery tool to a couple of specific situations: to depositions to obtain testimony to use in a potential future suit, or to investigate a potential claim or a suit to figure out whether you have something you can file.
The core issue in the case was whether this pre-suit proceeding, which is not yet a full lawsuit, can be removed to the business court.
So before we get into the court's analysis on this specific case, let's briefly set the stage. Rafe, what is the factual background that we're dealing with here?
So the dispute arises from Mark Cuban's sale of his majority interest in the Dallas Mavericks basketball team to members of the Adelson family. When Cuban sold to Adelson, he kept a right to participate in certain future business ventures relating to the Mavs. It was announced that the Mavs may be moving arenas, maybe even to an abandoned shopping mall north of Dallas, which was purchased or potentially purchased by a company called Arena Development Intermediate LLC. We'll call it ADI. Cuban believed ADI was held in whole or in part by Adelson. So the petitioners in the 202 proceeding were two of Mark Cuban's companies who believed ADI was backed by Adelson and therefore tortiously interfering with Cuban's right to participate in developing the new Dallas Mavericks arena.
That's right, Rafe. The Cuban companies Radical Hoops Ltd. And Radical Mavericks 2 LLC filed a Rule 202 petition to conduct pre-suit discovery to explore these potential tortious interference claims.
So those entities filed suit in district court, but ADI showed up and they removed the petition to the business court. Cuban's companies immediately filed an emergency motion to remand, arguing that the removal was improper because the case filed in the business court has to be an action within the court's jurisdiction. Cuban's companies contended that an action means a lawsuit, and a 202 proceeding is not a lawsuit. So how did the court structure its analysis of that question, Kate?
So the court broke down its analysis by answering two questions. The first was whether a Rule 202 proceeding is an action under the business court removal statute. The second question is, if the answer to the first question is yes, then does that action fall within the business court's subject matter jurisdiction? So let's take those in order. The first question, is a Rule 202 petition an action under the removal statute, Rafe?
Yes, it is. As it has at most points since its formation, the business court interpreted its jurisdiction broadly. It focused on the meaning of the word action under the business court's enabling statute, a word that it has looked at before. The court held that a Rule 202 proceeding is an action because the party bringing the suit is seeking to enforce a claimed right. Or a 202 petition, that claimed right is the right to conduct pre-suit discovery, while in a lawsuit, it's usually a claimed right against the defendant. So an action includes proceedings like lawsuits, but it also includes Rule 202 petitions according to the business court. So having answered the first question, yes, Kate, what was the answer to the second question, whether the court has subject matter jurisdiction?
Also yes. So the respondent's notice of removal in this case alleged the existence of two qualified transactions giving rise to the Cuban company's potential tortious interference claims. Those qualified transactions were the multi-billion-dollar sale of Cuban's majority ownership interest in the Mavericks, and a second agreement, an arena site option agreement, which was valued in the notice of removal at $50 million. So based on these allegations of the notice of removal, the court found that the 202 petition was within the court's subject matter jurisdiction because it involved qualified transactions and satisfied the statutory amount in controversy requirement. So Rafe, what are the key takeaways for practitioners with this case?
I think a key takeaway is the business court's jurisdiction extends to Rule 202 petitions. That clears a path and opens the business court's doors even wider for potential litigants who meet the statutory requirements to come into the business court and obtain orders for pre-suit depositions and pre-suit discovery. So if there's a high-value business dispute brewing that would fall within the business court's jurisdiction, a party's 202 petition filed in state court is potentially removable to the business court, from district court to the business court, or a 202 petition can be filed directly into the business court.
And perhaps a broader but related takeaway, Rafe, is that this case is a reminder that the business court's jurisdictional jurisprudence is still actively developing, and it will continue to do so, and we believe continue to open that jurisdictional door wider as the court continues to encounter novel procedural questions like this one. So thanks for watching the Texas Business Court Insider. Be sure to hit like and subscribe and get notified of our new videos. And check out our Texas Business Court Insider Hub via the link below to see our older videos and other thought leadership.